back, everyone, to criminal law and to the 6th lecture of our Elements of Liability module. But where are we exactly? Well, let's take a moment to recap. In the first lecture of this module, we covered the first element of liability, the requirement of a voluntary act. After that, we began our march to understand the second element of liability, mens rea. In the second lecture, we covered the common law approach to the topic, and then in the third lecture, we covered the model penal code approach to mens rea, which, as you now know, is a central focus of this class. In that lecture, we learned about the MPC's most important mens rea definitions and interpretive rules. And then we practiced using both to conduct element analysis, which is the process of matching culpable mental states to objective elements to clearly specify the government's mens rea burden of proof. So then in the next lecture, we started exploring the mens rea's relationship with two important psychological phenomena, mistakes and ignorance. After discussing the shortcomings of the common law approach to dealing with these phenomena, we focused on the MPC's logical corollary approach. In the process, we came to see how element analysis clarifies the legal relevance of mistakes and ignorance to individual prosecutions. Just ask whether the presence of the mistake or ignorance necessarily precludes the government from proving a required culpable mental state beyond a reasonable doubt. So in most situations, this kind of failure of proof analysis provides a definitive answer to the issue of liability, but not always. Because under limited circumstances, the application of a logical corollary approach can create legal loopholes and support injustice. In the last recording, we studied two of these situations. The first was a situation of the willfully blind actor who lacks guilty knowledge because they had intentionally stuck their head in the sand. Here, the criminal law imputes guilty knowledge on an individual who had suspicions that a circumstance existed, but purposely avoided acquiring guilty knowledge of that circumstance to preserve a defense to criminal liability. The second situation we discussed in the last recording involved exceptional circumstances in which someone prosecuted for a crime lacked fair notice of the criminal law, or because they reasonably relied on an official misstatement of the law and thus lacked awareness of the criminality of their conduct. Although this person's ignorance or mistake of law doesn't expressly negate a culpable mental state requirement, the criminal law does go beyond a logical corollary approach and affords a special excuse defense to criminal liability. Okay, so that's where things stand. We've now worked through some pretty challenging material, and you all have done a great job so far. As a result, I want to offer you a drink to celebrate. Well, not an actual drink, but a metaphorical one, because today's lecture is on a finely aged topic, intoxication. Intoxication poses many challenges to criminal policy, but none is greater or more urgent than understanding the impact of intoxication on proof of mens rea. It's an unfortunate reality that many people who become intoxicated commit crimes. And when they do, it's sometimes the case that their intoxicated state appears to preclude the government from establishing the subjective culpability, that is, the purpose, knowledge, or recklessness, required by an offense definition. So a logical corollary approach suggests these individuals should avoid criminal liability. But at the same time, exculpating people for their intoxication seems to conflict with considerations of fairness and public safety. Understanding how the criminal law deals with this tension is the focus of this recording. Today, we're going to be studying two major approaches to voluntary intoxication doctrine, the common law approach and the model penal code approach. So there are four main learning objectives for today's lecture. First, I'm going to introduce you to the different challenges that intoxication presents for criminal policy. In so doing, I'm going to try to provide you with a clear appreciation of the criminal policy's greatest challenge, which we'll be primarily focusing on in this class: voluntary intoxication, which negates one or more of the culpable mental state requirements that apply in an offense. The second learning objective is to teach you about the common law strategy for facing this challenge, precluding the presentation of intoxication evidence even in situations where it might be legally relevant. Third, we're going to carefully study the model penal code's alternative approach to the problem, imputing recklessness in situations of voluntary intoxication. Fourth and finally, we'll consider how these mens rea policies change in situations involving involuntary intoxication. In the process, we'll study how the criminal law differentiates between the categories of voluntary and involuntary intoxication. So with that, let's dive in. Okay, so I want to start today's recording by stating a basic empirical fact. Many people who commit crimes are intoxicated, and that's particularly true of violent crimes. As the US Supreme Court has recognized, violent crimes are overwhelmingly committed by people who are under the influence of intoxicants. And that shouldn't at all be surprising, given what intoxication does and how it operates for people. But okay, what is intoxication? Well, I suspect that at least some of you watching this video have some personal experience with the phenomenon, or maybe you at least know someone who has. But for now, let's set that personal experience aside and focus on the legal definition provided by the Model Penal Code. MPC Section 2.08 defines intoxication as a disturbance of mental or physical capacities resulting from the introduction of substances into the body. As a general principle, these disturbances begin with the introduction of a small amount of an intoxicant and then grow as a quantity of the intoxicant consumed increases. Although there's great variety in the forms and effects of intoxicants, it's often true that the consumption of even a moderate amount can have a significant impact. That is, by diminishing a person's capacity to understand their surroundings, to appreciate social norms, or to control their actions. And it's also often true that when people consume significant amounts of intoxicants, extreme things can happen, like blacking out, being divorced from one's sense of morality, or completely losing control over your actions. So this poses a challenge for the criminal justice system because the mental activities and abilities that intoxication negates tend to be the things that mens rea policies care about. So for example, consciousness, awareness of risk, rationality, and self-control. These are all generally considered to be preconditions for deeming a mind to be blameworthy. So when people do bad things without them, as is the case with small children and those suffering from severe mental illness, we begin to question whether they actually deserve punishment rather than just our sympathy. And yet, there may also be a critical moral difference between the psychological impairments of children, the mentally ill, versus those of the intoxicated actor. After all, the former didn't choose their impairments, whereas the intoxicated actor did. Or did they? Well, sometimes people become intoxicated involuntarily. Say, for example, because someone spiked their drink, or because they're experiencing the unexpected effects of a new medication taken pursuant to medical orders. And anyways, just how blameworthy is the choice to get intoxicated? It is one that millions of Americans and billions of human beings make. Okay, so as you should already be able to tell, intoxication raises some pretty challenging problems. And there are problems that the criminal law has historically done a pretty terrible job of grappling with. The common law of intoxication is often as incoherent as it is messy. More recently, the situation has improved, with modern criminal law developing a Marie Kondo-style solution to the problem: identify, categorize, and distinguish. So okay, the first and most important distinction to understand are the three fundamental ways that intoxication can complicate criminal liability. The first complication is by rendering someone temporarily insane. Typically, the ability to distinguish between right and wrong and to control one's conduct is a prerequisite to criminal liability. That's why we don't criminally punish very small children, and it's also why we provide some people who suffer from severe mental illness with an insanity defense. Some people who take intoxicants experience a temporary disturbance to their rationality and volitional capacities that puts them in a similar space. Under these circumstances, the specific question is whether intoxicated individuals should be afforded a comparable excuse defense based on their temporary insanity. The second fundamental way that intoxication can complicate criminal liability is by precluding the existence of a voluntary act. To illustrate, consider the following scenario. Someone drinks a lot, then picks up a gun in their backyard. A few minutes later, they lose consciousness, and in the process, they drop their gun on the ground. On impact, the gun fires and kills a small child nearby. Now this individual is prosecuted for negligent homicide. A skillful defense attorney will argue that they can't be convicted because they lack a critical element of criminal liability: a voluntary act understood in terms of a bodily movement that's the product of conscious effort and determination. This kind of voluntariness claim is very different than a temporary insanity claim. And both of those claims are distinct from a claim involving the third fundamental complication intoxication can pose to criminal liability: that someone lacked the requisite mens rea necessary for an offense. Consider the unfortunately common situation of an intoxicated person who gets behind the wheel of a car. This person is so drunk that they fail to see they're approaching a crosswalk, or that there's a pedestrian about to walk into that crosswalk. As a result, this drunk driver kills a pedestrian and is thereafter charged with knowing murder or reckless manslaughter. Under these circumstances, a skillful defense attorney is going to argue that their client can't be convicted because they lack the conscious awareness of a risk necessary to establish either of these subjective forms of culpability. This kind of absence of mens rea claim is distinct from a lack of voluntary act claim or a temporary insanity claim. It raises different conceptual issues and presents distinct evidentiary challenges. Given these distinctions, the criminal law has developed different doctrinal rules to deal with each of these three claims. But the content and application of those rules differ depending on another key distinction recognized by the criminal law: whether the underlying intoxication was voluntary or involuntary. Voluntary intoxication, or what's sometimes called self-induced intoxication, is basically intoxication that was freely chosen. As the Model Penal Code defines it, self-induced intoxication is intoxication that's caused by substances that the actor knowingly introduces into his body, the tendency of which to cause intoxication he knows or ought to know. Okay, so from the criminal law's perspective, the choice to get intoxicated matters. Because intoxication is known to be dangerous, the fact that someone freely chose that danger is considered to be an independent basis for blaming them. This basic idea informs the restrictive and typically government-friendly rules that govern situations of voluntary intoxication. So most often, intoxication is voluntary, but not always. Sometimes people are forced or tricked into taking an intoxicant, or they may experience unexpected intoxicating effects from a prescribed medication, or they may experience extreme effects from an intoxicant that are grossly excessive in degree to what the actor reasonably should have expected. So in these kinds of situations, the person's intoxicated state was not freely chosen, and so it was involuntary from the criminal law's perspective. With that different perspective comes a different set of rules. Because involuntarily intoxicated actors aren't necessary to blame for their situation, the criminal law approaches dealing with them differently across the three different types of claims we previously discussed. So when you take this all together, there are about 6 basic doctrinal boxes which result in the modern law of intoxication from 2 main axes. The first axis is the nature of the intoxication, that is, whether intoxication is voluntary or involuntary. And the second axis is the impact of the intoxication, whether it led to temporary insanity, the absence of a voluntary act, or the absence of mens rea. All 6 of these doctrinal boxes are important, but one of them is by far the most significant, as well as the one most likely to be raised in an individual prosecution. And that's voluntary intoxication, which negates mens rea. So that's what we're going to spend most of this recording focusing on. The voluntarily intoxicated actor who claims to lack mens rea challenges the criminal law in a way that's very similar to what we previously discussed in the context of willful blindness. On the one hand, it's undeniably true that a voluntarily intoxicated actor may lack the subjective awareness of risk required by culpable mental states like knowledge or recklessness because of their intoxicated state. So for example, consider again the situation of a drunk driver who speeds through a crosswalk unaware of the substantial risk of death she's creating for the pedestrian stepping into it. If sober, this driver may very well have carefully scanned the crosswalk, seen the pedestrian, and then promptly slowed down. But after a dozen drinks, this driver is no longer her normal, careful self. As a result, she fails to recognize that she's even nearing a crosswalk, let alone that there's an innocent pedestrian walking into it. And yet, if this driver is prosecuted for knowingly or recklessly killing the pedestrian, her absence of awareness should preclude a conviction under a strict logical relevance approach, for the simple reason that she lacked the subjective awareness of risk that the government is otherwise required to prove. So then, should we just adjudicate her not guilty of murder and manslaughter and move on? Not so fast, many would say. True, this person may technically lack mens rea, but let's consider why. Because she chose to get intoxicated. So to let her off the hook just may not seem right given her prior culpable conduct, just as it didn't seem right in the case of the willfully blind actor who stuck their head in the sand to avoid criminal liability. Okay, so that's the challenge presented by voluntary intoxication negating mens rea. Now let's consider the criminal law's 2 main approaches for dealing with it: the common law approach and the model penal code approach. Let's start with the common law approach. That approach focuses on the argumentative and evidentiary realities surrounding the presentation of an intoxication claim. That is, someone who's charged with committing a crime while voluntarily intoxicated will try to argue that they lacked mens rea due to their intoxicated state, and then they'll seek to introduce evidence in support of their claim. But for the reasons we just discussed, allowing that kind of argument and evidence could lead to problematic results. So the common law's solution is as blunt as it is simple. Bar the defendant from raising voluntary intoxication as a defense to negate mens rea, and also bar the defendant from presenting intoxication evidence in support of that defense. This limitation significantly increases the government's ability to prove mens rea in situations of voluntary intoxication because it takes away a particularly potent source of argument and evidence to negate it. Because of this, it's sometimes said that the common law approach reduces the government's burden of proof in situations of voluntary intoxication in the sense of making the burden of proof easier to bear. Historically, the common law has applied this restrictionist approach to dealing with voluntary intoxication to some, but not all crimes. The traditional common law rule is that these restrictions only apply to so-called general intent crimes. By contrast, for so-called specific intent crimes, the common law has historically allowed defendants to argue that they lacked mens rea due to voluntary intoxication and to present relevant evidence in support of that claim. So, for example, someone being prosecuted for the so-called general intent crime of assault under the common law could not argue or present evidence in support of a claim that they lacked the mens rea of assault due to their voluntarily intoxicated state. However, someone charged with assault with intent to kill could argue that they lack the specific intent to kill due to their voluntarily intoxicated state and would therefore be able to present legally relevant evidence of intoxication in support of the claim. In the latter case of specific intent crimes, one might say that the common law sort of accepted a logical relevance approach in which voluntary intoxication could provide a failure of proof defense, provided the jury considered the intoxication evidence and concluded that the defendant did in fact lack the mens rea required by an offense because of it. So this common law approach may sound simple enough in theory, but in practice it's caused many difficulties. One reason for this is that the approach depends upon the distinction between general intent crimes and specific intent crimes. And yet, these two categories are unwieldy and unreliable. In most situations, there's nothing inherently general or specific intent about a crime. Instead, courts would just slap these labels on after the fact based on their feeling of whether voluntary intoxication should be a defense. Second, the straightforward restrictionism of the common law approach papers over some pretty complex constitutional issues. On the one hand, people charged with general intent crimes can't argue they lacked mens rea due to their voluntarily intoxicated state, and they can't present evidence of their voluntarily intoxicated state. But on the other hand, the government is still required to prove mens rea beyond a reasonable doubt in all cases. And that's true even where a voluntarily intoxicated actor is prosecuted for a general intent crime that may actually entail proof of subjective awareness as to some aspect of the offense. And so what happens in a situation where the defendant actually does lack mens rea due to their intoxicated state? Shouldn't allowing the government to convince a jury that the defendant possessed a mental state that they otherwise lack violate due process? That, as it turns out, was a difficult question presented to the U.S. Supreme Court in a case called Egelhoff. In a closely divided 5-4 vote, the Egelhoff majority held that a conviction under these circumstances would be constitutional, though the members of the majority disagreed on exactly how and why this restrictionist approach preserves the government's burden to prove mens rea beyond a reasonable doubt. These kinds of problems were at the forefront of the MPC's drafters' minds when they analyzed the common law approach to voluntary intoxication. Based on what they observed, the drafters opted to develop a very different policy solution to dealing with the problem of voluntary intoxication. That solution involves a strategy we previously encountered in the context of willful blindness, what's called imputation. Imputation basically says that under certain circumstances, the criminal law will treat someone as though they possessed a mental state, even if they didn't actually possess it. Under the Model Penal Code, voluntary intoxication provides the basis for imputing a culpable mental state of recklessness as to one or more offense elements. That is, as Section 2.082 phrases it, when recklessness establishes an element of the offense, if the actor, due to self-induced intoxication, is unaware of a risk of which he would have been aware had he been sober, such awareness is immaterial. In a moment, I'm going to explain to you how this specific provision works. But first, I want to situate the provision in broader statutory context. The Model Penal Code approach to voluntary intoxication actually begins with Section 2.081, which states in relevant part that intoxication of the actor is not a defense unless it negatives an element of the offense. Okay, so what does that mean? Well, the formulation here is a bit confusing, but once you subtract out the double negative, you're left with a simple idea that intoxication is a defense whenever it logically precludes the government from meeting its burden of proof. If that sounds familiar, that's because it is. This is basically the same principle of logical relevance we saw in the context of the NPC approach to mistaken ignorance applied to the issue of intoxication. The basic idea is that intoxication, whether voluntary or involuntary, constitutes a failure of proof defense when, but only when, it precludes the government from meeting its burden of proof. This logical relevance principle is intended to codify the common law approach to dealing with voluntary intoxication in the context of so-called specific intent crimes by applying a failure of proof analysis to the culpable mental states of purpose and knowledge. That analysis is very similar to what we previously encountered for mistakes and ignorance. Basically, a person who's prosecuted for a crime of purpose or knowledge is always able to argue and present legally relevant evidence of their intoxicated state when, but only when, it negates a conscious desire or awareness as to a practical certainty required by purpose or knowledge in an offense definition. Here's an illustration of what this means and how this logical relevance principle plays out in practice. Let's return again to the situation of our voluntarily intoxicated driver. Let's call her Dina, who runs over a pedestrian entering a crosswalk. Let's call her Vero. Here again, I want you to imagine that Dina was so intoxicated that she didn't realize she was driving through a crosswalk, let alone that Vero was stepping into it. As a result, Dina hits and kills Vero upon impact. Given the fatal accident, Dina is prosecuted under a statute which prohibits purposely or knowingly killing another person. At trial, Dina seeks to introduce evidence of her intoxicated state to argue that she lacked the purpose or knowledge as to Vero's death necessary to secure a conviction. Based on the NPC's general principle of logical relevance, codified in section 2.081, the trial judge will grant Dina's request because her intoxication can, in fact, negate the conscious desire or practically certain level of awareness that the government is required to prove beyond a reasonable doubt. Of course, even in the face of this evidence, the government may still try to prove that Dina was practically certain or consciously desired to kill Vero, even with her intoxicated state. But the government will lose here based on the facts I've given you. That said, it's important to be really clear about something. Just because someone is intoxicated does not mean they necessarily or actually lack the purpose or knowledge required by an offense. Intoxicated people can, and often do, consciously desire to kill, rape, or steal. And they can also be aware of a victim's age, the value of property, whether a gun was loaded, or any other circumstantial fact required by an offense. When that happens, they can still be convicted for committing these crimes under a logical corollary approach for a very simple reason. Their intoxicated state doesn't actually negate the required mens rea under the facts of the case. So, in short, just because someone is in principle able to present a voluntary intoxication defense to a purpose or knowledge crime under the NPC does not mean their intoxication provides a winning defense. That only happens if and when the fact finder is left with a reasonable doubt as to whether the defendant lacked the required mens rea by virtue of their intoxicated state. Nevertheless, and again, under a logical relevance approach, this is a claim that the defendant is actually allowed to make and to present evidence in support of in prosecutions for purpose and knowledge crimes. By contrast, for negligence crimes, the analysis shifts, and that's true even under a logical relevance approach. The general rule is that in negligence prosecutions, a defendant is not allowed to argue or present evidence that they lacked mens rea due to their voluntary intoxication. But why do you think that is? That is, what is it about negligence liability that makes evidence of voluntary intoxication logically irrelevant in the eyes of the criminal law? If you can, pause the recording for a moment to reflect. Okay, welcome back. Under the principle of logical relevance, evidence of voluntary intoxication doesn't negate negligence for the simple reason that negligence is largely an objective form of culpability. That is, under the NPC, negligence requires proof that the accused should have been aware of a substantial and unjustifiable risk, which is understood in terms of what a reasonable person would have been aware of under the circumstances. Here, however, the legal point of comparison is to the reasonable, sober person, which is to say, someone who possesses their normal faculties of awareness and control, and not the reasonable intoxicated person who is experiencing the impairments normally associated with intoxicants. This follows from the criminal law's perspective on the general immorality of intoxication. The criminal law would say that it's arguably both dangerous and blameworthy to knowingly blunt one's faculties of awareness and control. Therefore, involuntary intoxication does nothing to negate negligence for the defendant. And indeed, just the opposite is true. Voluntary intoxication may often be proof of negligence. As a result, the government will often rely on voluntary intoxication evidence to prove the existence of negligence in particular situations. The MPC commentary sums this up nicely when it states that for negligence, the actor's culpability in failing to perceive a risk would be judged against the standard of a man in normal possession of his faculties. Thus, the fact that the defendant was drunk will not exculpate him from a charge of negligence. Indeed, often drunkenness would be substantial evidence that he had acted negligently. Okay, so now let's illustrate what all this means by returning once again to the Dina prosecution. Let's assume the same facts. A drunken Dina is so severely intoxicated, she was completely unaware of any risk to Vero, who she fatally struck while speeding through a crosswalk. Now, though, I want you to imagine that Dina is prosecuted for negligently killing Vero. At trial, Dina seeks to introduce evidence of her intoxicated state to argue that she was not negligent. The trial judge will deny Dina's request on the basis that voluntary intoxication doesn't help to prove Dina acted reasonably. At trial, the government also seeks to introduce evidence of Dina's intoxication to prove negligence. The trial judge will grant this request on the basis that intoxication helps to prove Dina acted unreasonably. At the close of trial, the jury will likely find that Dina should have been aware of a substantial risk of death to Vero, and therefore convict Dina of negligently killing her. So far, so good? I hope so. Okay, so now that we understand how the MPC's logical corollary approach deals with purpose, knowledge, and negligence, let's take a look at what the MPC does with recklessness imputation. Once again, the relevant provision, section 2.082, states the following. When recklessness establishes an element of the offense, if the actor, due to self-induced intoxication, is unaware of a risk which he would have been aware of had he been sober, such unawareness is immaterial. Okay, so what does this mean? Basically, this provision says that even if the defendant lacks the awareness of a substantial risk necessary to prove recklessness, the law will nevertheless treat them as though they possess it, provided the government can meet a couple of conditions. First, the government has to prove that their intoxication was voluntary, or to use the MPC lingo, self-induced, which is governed by the definition we discussed at the start of the recording. Second, the government would have to prove that the individual would have been aware of the risk and thus had been reckless had they been sober. In situations where the government can meet these requirements, the MPC would impute recklessness onto the voluntarily intoxicated actor. If this kind of approach sounds familiar, well, that's because it is. We confronted a similar kind of legal framework in the context of willful blindness. As we previously discussed, the common law imputes guilty knowledge onto someone who is aware of a substantial risk of some fact, but avoids acquiring guilty knowledge to preserve a criminal defense. The common law embraces this imputation rule to avoid rewarding people who stick their head in the sand to avoid criminal liability, and to ensure that willfully blind actors who are just as culpable as knowing actors are treated comparably. A similar logic rests behind the MPC's imputation rule in section 2.08. For intoxication, like willful blindness, we're presented with a situation where strict application of a logical corollary approach seems to create a legal loophole for actors who can't be convicted of recklessness crimes because of their prior culpable conduct. To let people who've voluntarily chosen to become intoxicated off the hook due to their lack of subjective awareness strikes many as unfair and dangerous. So the MPC solution is to impute that subjective awareness in recklessness prosecutions involving voluntary intoxication. Okay, so that's an explanation of the rule. Now let's consider how it applies in practice. To do that, let's return once again to our hypothetical involving a drunken Dina who is so severely intoxicated she was completely unaware of any risk to Vero, who she fatally struck while speeding through a crosswalk. Now, however, I want you to imagine that Dina is prosecuted for recklessly killing Vero, what's viewed as manslaughter in many jurisdictions. Under these circumstances, what is the government's burden of proof, and can the government meet it? Okay, so normally a conviction for reckless manslaughter, that is, recklessly killing another person, requires proof that the accused consciously disregarded a substantial and unjustifiable risk of death. The government is, of course, free to pursue this normal route, even in prosecutions involving voluntary intoxication. After all, it's entirely possible for someone who's intoxicated to be aware of a risk of harm prohibited by statute. Indeed, one could imagine that many, if not most, intoxicated people consciously disregard risk all the time. However, in Dina's case, I've already told you that Dina specifically lacked any subjective awareness of risk. As a result, the government could not prove recklessness through the normal route. Fortunately for the government, MPC Section 2.08 provides an alternative way to establish recklessness under these kinds of circumstances. First, the government has to prove that Dina was voluntarily intoxicated, which is to say, in the words of MPC Section 2.085, that Dina's intoxication was caused by substances that the actor knowingly introduced into his body, the tendency of which to cause intoxication he knows or ought to know. That should be easy to prove here, since there's no question Dina was drunk off of alcohol, which she knew or had reason to know would impair her faculties. Having proven that Dina was voluntarily intoxicated, the government would then move on to the next requirement, that Dina would have been aware of a substantial risk of death to Vero had she been sober. This is the core of the MPC's imputation rule. It effectively asks a fact finder to imagine a world in which Dina was engaging in the same conduct, save one key fact. She's sober rather than drunk, and then consider what the defendant would have been aware of. This kind of analysis may strike some of you as strange, and to some extent it is, but it's also nothing out of the ordinary. As you'll learn in the next topic of causation, sometimes the criminal law requires fact finders to engage in counterfactual inquiries about how the world might have looked without the defendant's conduct. This is one of those situations. Unfortunately, for intoxication under the MPC, there's surprisingly little case law or discussion about how this hypothetical analysis is intended to operate. But as a general principle, you can assume that if the risk would have been obvious to a reasonable sober person, and if the defendant had no major cognitive or physical impairments before they got drunk, well then the defendant would have been aware of the risk had they been sober. And that seems to be the case here, based on the facts I provided you with. So you can assume that the second prong of the MPC's recklessness imputation approach is met, in which case Dina will be convicted for manslaughter for recklessly causing Vero's death. Does that make sense? I hope so. So we'll spend more time going over this in class. But for now, I want to take a moment to illustrate the difference between the MPC and common law approaches by focusing on an important tool in criminal cases: jury instructions. Jury instructions are, in short, the instructions that juries are provided with by the court about governing law in order to render an accurate verdict in criminal cases. So they play an essential role, and as a result, they have to translate legal tests and concepts into an accessible narrative that people without legal training can understand and apply. Normally, jury instructions are developed by committees made up of experienced practitioners who have a good feel for what the jury needs to know and the best way to convey it to them in an actionable way. So with that in mind, I want to provide you with some sample jury instructions on voluntary intoxication as a way to review what we've learned and illustrate the differences between the two approaches we've been considering in this recording. Let's begin with the common law approach to the problem. As you might recall, that approach bars the defendant from arguing that he lacked mens rea due to his voluntary intoxication and limits the presentation of evidence in support of that claim in prosecutions for general intent crimes. By contrast, that approach generally does nothing to bar the presentation of legally relevant intoxication evidence by the government to prove the existence of mens rea. And even in circumstances involving voluntary intoxication, the government retains the ultimate burden to prove mens rea beyond a reasonable doubt. With that in mind, let's consider how a jury might be instructed in a prosecution for a general intent crime where the government has tried to use voluntary intoxication as proof of mens rea. Okay, so here's the instruction. The defendant has been charged with an offense that requires that she have acted with the general intent to commit the crime of blah. In this jurisdiction, a general intent means blah. However, in considering whether the defendant possessed this mental state, you shall disregard any evidence of the defendant's voluntary intoxication insofar as it negates findings of culpability that you would otherwise have to make. Accordingly, you shall find the defendant guilty if and only if you find that the evidence shows that the defendant acted with the general intent to commit the crime of blah, evidence of her voluntary intoxication to the contrary notwithstanding. Okay, so that's a sample instruction applying the common law approach. Now let's compare it with a sample instruction on the MPC's recklessness imputation approach, which affords jurisdictions with an alternative means of proving recklessness in situations of voluntary intoxication. Okay, so here's the instruction. The defendant has been charged with the offense of blah. This offense requires the government to prove a mental state of recklessness as to the objective element of blah. Ordinarily, recklessness requires proof that the defendant consciously disregarded a substantial risk as to an objective element. However, in this jurisdiction, a person who's voluntarily intoxicated and would have otherwise been aware of a substantial risk as to an objective element, but for their intoxicated state, is also considered to be reckless. Accordingly, you may find the defendant guilty if you find either that she possessed a mental state of recklessness with respect to the objective element of blah, or that she lacked a mental state of recklessness that she would have otherwise possessed had she not been voluntarily intoxicated. Voluntary intoxication means intoxication that was caused by substances that the actor knowingly introduces into his body, the tendency of which to cause intoxication he knows or ought to know. Okay, does that make sense? I hope so. All right, so with that, there's one final point I'd like to discuss in this recording. And that's the situation of an involuntarily intoxicated actor claiming they lacked mens rea due to their intoxicated state. As I mentioned earlier in this lecture, an involuntarily intoxicated actor is someone whose intoxication was not freely chosen. Because their intoxication was not freely chosen, there's a strong argument that we shouldn't blame them for it. As a result, a different set of rules apply. Those rules are generally less developed in US criminal law, in part because cases involving involuntary intoxication are pretty rare. Nevertheless, in this class, we're going to learn the following general principle. Involuntary intoxication is a defense whenever it negates a required mental element. Basically what we saw earlier with respect to MPC section 2.081. But let's consider what this means for both approaches. So under the common law approach, an involuntarily intoxicated actor should always be free to present legally relevant evidence about their intoxicated state to prove the absence of mens rea. And that's true even when they're being prosecuted for a general intent crime. Under the model penal code approach, recklessness imputation entails proof of voluntary intoxication, and that proof would not exist in a situation of involuntary intoxication. As a result, in any situation where an involuntarily intoxicated actor lacks the subjective awareness of a risk necessary to establish recklessness due to their involuntarily intoxicated state, they should be acquitted due to the absence of mens rea. Along similar lines, involuntarily intoxicated actors prosecuted for negligence crimes should be able to present evidence of their intoxicated state as a defense for the simple reason that their intoxicated state would be reasonable. In that case, the appropriate question to ask would be whether a reasonable person in the defendant's involuntarily intoxicated state would have been aware of a risk. If not, and I think more likely than not, the answer will be not, then the person should be acquitted due to the absence of mens rea. Okay, so that's a quick overview of what a logical relevance approach to involuntary intoxication would look like. As you might imagine, under this approach, actors raising failure of proof claims based on involuntary intoxication are much more likely to succeed than those who raise them based on voluntary intoxication. The critical issue that remains is who exactly is entitled to these more defense-friendly rules. Generally speaking, the criminal law recognizes 4 kinds of actors who count as involuntarily intoxicated: the coercively intoxicated, the pathologically intoxicated, the innocently intoxicated, and the medically intoxicated. Coerced intoxication is more or less what it sounds like. Intoxication induced coercively, which is to say against someone's will. So for example, imagine that mafia boss Bob presents Jane with a choice: take this drug or be shot. If Jane takes the drug, then any resulting intoxication would be deemed involuntary. Pathological intoxication is a situation of someone who ingests an intoxicant not knowing of their special susceptibility to its effects. So for example, imagine that Jane drinks her first beer on her 21st birthday, only to discover that she has an autoimmune disease, which multiplies the effects of beer 100 times over. In that case, the law would view this exponentially drunk Jane as being pathologically intoxicated. Mistaken intoxication covers a situation of someone who's tricked into taking an intoxicating substance or otherwise has no reason to know that the substance they're ingesting is intoxicating. So for example, if Sneaky Bob secretly puts cocaine or some other intoxicant in Jane's smoothie, well then Jane's resulting state of intoxication would be involuntary. Finally, medical intoxication occurs where someone takes a medication as prescribed and experiences intoxicating effects while performing a task consistent with doctor's orders. So for example, if Dr. Bob prescribes Jane with a new cancer treatment and tells Jane she can safely drive while she's on it, but then Jane becomes intoxicated while driving, well then that intoxication would be involuntary. So look, I think these 4 categories are all pretty intuitive in that the intoxicated state of each actor doesn't seem blameworthy, and so the special rules governing voluntary intoxication don't seem appropriate in this context. As a result, these voluntarily intoxicated actors are more or less free to use their intoxicated state to try to negate mens rea as they so choose. Or at least that's the idea, because again, in practice, claims of involuntary intoxication are infrequently raised, and even less frequently are they successful. Okay, so I think it's enough talk about intoxication for one recording. With that, please go ahead and complete the class readings and assignments. I'll look forward to discussing with you all during our next class. Take care.